The Department and Agency Subcommittee is now in session. Today's Tuesday, March 8th. We're in hearing room 3 at 3 p.m. We got a little bit of housekeeping to do. Maybe I'll give members a few minutes to arrive. It's been a day for everybody, I think. So, looking at the calendar, item number 3, HB 349 by Johnson, is rolled to the hill of the calendar. Item number 4 is rolled 3 times, so it's going to be sent to the special calendar. Item number 5 is rolled 1 week. Item number 8, HB 2387 is off notice. Item number 9, HB 1749, rolled to the hill of the calendar. Item number 11, HB 2133 is rolled 1 week. Is that all of them? Yes, sir. Okay, and that kind of straightens that mess out to start with. Motion denied. Lisa, please call roll.
Chairman Kiesling. Beck.
Here.
Bricken.
Here.
Carr. Carringer. Chisholm.
Here.
Halford. Chairman Holsclaw.
Present.
Chairman Holsclaw, we have a quorum.
Okay, and what I'm going to, well, who do I need to pass to? Start taking over the ones. Okay, we're going to skip down to item number 6, which is HB 2867 by Travis.
Motion. Second.
We got a motion and a second.
Thank you,
And
Mr. Chairman and committee.
Item number 6.
Item number 6 is in the code 573204. And back in 1939, this was added to the code to keep a spouse of a law enforcement officer from opening a alcoholic store, a liquor store, or a spirit store. And I think we have some people that want to talk on this one. So, Chairman, it's at your discretion if you want to go out of session and hear from.
Let's hear your explanation of the bill first.
Okay. What this bill will do, right, as present, it will take the language of the spouse not being able to own or operate a liquor store. It'll go back and, first off, I would like to say Happy International Women's Day, and this is the lady that we're representing today, Camellia. If you don't mind, I'd like to take you back in time to 1939. Where 1 out of 4 women worked outside the household. It was right after Prohibition, where moonshine and was wild and free in the state. And rules were a little relaxed, and the world was changing. We were yet to see the Second World War and just come out of the worst depression we have ever seen. That's when we put this restrictions on this bill in our state. I do understand why, and if I was here in 1939, I would have voted for it. And we have all heard what the times were back then. And with that, we're just asking that it will be allowed that the spouse of a law enforcement agent would be able to own and operate their own liquor store.
Committee members, questions? You're recognized, Representative Hoffman.
Thank you, Mr. Chairman. Do we have other people that are in this same situation as far as, let me think, judges, something like that? Do they fall in that category?
Yes, sir, they do. And we fall in that category. As lawmakers. We fall in that, and I understand why we should fall into that. I mean, we're lawmakers, and we do make the rules.
So are we opening the door?
Just on law enforcement spouses.
But are we opening the door for other folks like us and others for this to happen to
Not
us?
today. Not today. We're not opening the door today for that.
Thank you, Mr.
just,
Chairman.
You know, that's a good question, Chairman. But you know, when I took you back to 1939, today I'm going to tell you it's 2022. And you know, 9 out of 10 women work outside the home. I mean, they're professional women. She is a nurse. We have leaders of her state in this world that we live in today. And, you know, I was talking to my wife last night about this, and she didn't understand also, you know, why the law enforcement, I understand why the law was done in 1939 with the moonshine running and all that. But in today's time, I mean, you're talking about a 5-year college person with an education in nursing that would like to open her own business, and that would be a liquor store in her town. And we have letters from a lot of government officials in her town supporting her on this, and that's why we're here today.
Mr. Chairman.
You are recognized, Representative Hoffman.
So can that officer, he can't own a liquor store either?
No, sir. He can own a bar, but he cannot own a liquor store.
Really? So is he prohibited, but since he's not, can't own a liquor store, is he prohibited from participating in the gains from the liquor store?
Not that I'm aware of. I think it would be, you know, he has a job as being a police officer, and now she will have a job if she owns the liquor store. So, I mean, I'm sure that income would commingle, buying food, paying house payments, college payments for their kids. I'm sure the commingle funds would be there.
Thank you, Mr. Chairman.
How do you ensure that there's not favoritism to this officer or wife of an officer owning a liquor store?
Well, it's my understanding this will be the only liquor store in the town, so I don't know how favoritism would come in on that part. But, you know, in my town that I live in, we have 2 liquor stores in this town. And if my sheriff or just a police officer owned one, that wouldn't mean that I would have to frequent that liquor store as opposed to the other liquor stores. So I don't see any draw in that at all, Chairman.
Representative Carringer.
Thank you, Mr. Chairman. I just hearing this conversation, why do we keep saying the officer is a he and the spouse is a woman
that is
owning the package or liquor store? I mean, I have many friends, and our chief of police in Knoxville is a woman. So I just kept wondering, why are we referring to women owning when the woman could be the police officer and the spouse be he? So I just was wanting to clarify that as to why we are so much being about this, the spouse being the woman of the.
You're recognized.
Thank you, Mr. Chairman. And Representative, great question, because that's in my notes down in the bottom of this. It just happens today that Miss Grooms is a she and her husband is a he, and he is in law enforcement. But yes, it does reflect, if we take this out, and the lady you're talking about, who is the police chief, and her husband wants to open and own a liquor store or a spirit store, then that would be allowed if we took this out of the clause and just left it like it is. So that's a good point, but that is correct. It is he or she.
We do have one person that has notified us that does want to speak on the bill, and we'll go out of session and hear that testimony. We're out of session. We have Aaron Rummage from ABC. If you'll state your name and who you're with and give us some information. And you do have 3 minutes.
Thank you, Chairman. I'm Aaron Rummage with the Tennessee Alcoholic Beverage Commission. We do have some concerns about this. We work with local law enforcement all the time, and we think that, you know, if the police chief's spouse or the sheriff's spouse or even an officer's spouse is there, it's going to hinder us. We usually let them know about our operations. Additionally, the good sponsor, and I appreciate him, you know, advocating for the constituents, but I just wanted to clear a couple things up. This was actually a scandal in 1949 that it was an East Tennessee scandal that precipitated the law change. We had some sheriffs and mayors, basically the sheriffs and council members had all gotten together and owned 2 package stores in Lake City, and they were bootlegging all across East Tennessee. And so the General Assembly came back the next year in 1950 and passed a law to stop public officials, employees from having a liquor license. And that, corruption had gone on for 100 years before that. And we were having a hard time, the industry was having a hard time getting people to pass referendums, and we really needed to clean the industry up. And that's what the General Assembly came back and said, okay, no more public employees, no more mayors, no more sheriffs. Now, this will allow a spouse to have it, but when we look, and the law right now does not consider a spouse to be different than the licensee because they're sharing the money. And so, in fact, there's another provision that says the police officer can't touch any of the profits. So it's not enough just to say they can share the money. That we won't issue the license for that. But the main policy reason for this is to stop public corruption or even the appearance of corruption. And so for those reasons, we just feel like this is bad policy, and we just ask that you not support it. Okay.
I'd like also to refer to the legal on further explanation of the code and law.
Thank you, Matt Mundy from Legal. I just wanted to point out that we've actually done similar versions of this bill in the past, but there's an additional provision that really needs to be amended for purposes of certain clarity in Title 57, and that's just, this amends 204B2F, but B2K says if your spouse is ineligible to receive a license, then you're also ineligible, and we didn't amend that in this particular bill. And that probably needs to be rewritten so that it doesn't impact, we don't have a conflict in the law.
Okay. We'll go back in session. You are recognized, Representative Beck.
I just wanted to ask Mr. Mundy, so as we stand here today, we're asking for a police officer's spouse, not just wife, but spouse, to be allowed to own a package store. So if a teacher's spouse wanted to own a liquor store, or a dog catcher's spouse, we would have to amend the law. Is that correct? So we'd have to carving out.
No, I won't say that.
Is that correct, or am I not thinking right?
Thank you for the question, Matt Mundy from Legal. There's a exhaustive list of persons in certain categories who are prohibited from holding a license, and it doesn't apply to teachers and so forth, but it does apply to members of local legislative bodies, law enforcement officers, people who might be in a position of authority to where it might interfere with their ability to also manage a liquor store. At least I think that's the policy.
Very good, thank you.
And Mr.
You are recognized, Chairman Hoffer.
And so did you say if the officer himself is prohibited from owning that license, then his spouse is also?
Yes, thank you for the question. There's 2 different provisions. There's one that prevents law enforcement officials or those who supervise law enforcement officials from holding a license, but then there's a subsequent subdivision about 3 or 4 spaces down that says if your spouse is ineligible, then you're ineligible. So that would also capture the husband or wife of a law enforcement officer, because the law enforcement officer themselves is ineligible to hold the license. And I was just mentioning that to the sponsor for the purposes of how we proceed, that we should probably, to be sufficiently clear moving forward, that we amend both provisions so that there's absolutely no conflict in how we interpret this.
Thank you, Mr. Chairman.
You are recognized, Representative Travis.
Thank you, Mr. Chairman. And Matthew, thank you for the description on this. And that would be done with an amendment, correct? Okay, that would be fine. And,
All right. We're back in session.
oh, sorry.
And other questions by the committee?
What, and
You are recognized, Representative Travis.
Thank you, sir. And Aaron did a great job for ABC, and he's a good friend of mine also, and he does a great job, and the ABC does a great job at that department also. And if we found out anything lately, that none of us is above the law, liquor store, us, nobody's above the law. So when we talk about people that was prosecuted or we had a problem in 1949, that was in 1949. We're always going to have a problem with somebody somewhere. But I don't look for this to be in a problem whatsoever. You know, I feel comfortable. Ms. Grooms, I've talked to her today. She's a nurse by profession, so she's got a great education. She's a smart businesswoman. And I think all spouses should have the opportunity, if their person is a law enforcement, to at least to have the opportunity to have a liquor store or a business that they choose. And with that, Mr. Chairman, I would like to pass it on to full committee where I bring the amendment that Matthew had talked about.
Well, that's considering if it passes or not.
That's correct. Yes, sir.
Are we ready to vote? Questions, comments? Seeing none, those in favor say aye. Those opposed? No. Bill fails.
Thank you, sir.
We're on to item number 7, HB 2419. Okay. Okay. He's had all he could take. You are recognized on HB 2419, Representative Manis.
Thank you, Mr. Chair.
It looks like we do have an amendment.
amendment.
What's the drafting code you're showing?
It's 15013.
That would be correct. Motion and second. So you're properly before us. So rock and roll.
Thank you, sir. I'm bringing this on behalf of HB 2419. I'm bringing on behalf of our local restaurant owners across the state. This legislation is an effort to ask TASER to do a comprehensive look at the issues facing our local restaurants. Just a few statistics I want to present to the committee. Restaurants and drinking places account for 8.9% of all employment in Tennessee. An estimated 76% of eateries in Tennessee are independently owned. 9 out of 10 restaurants have fewer than 50 employees. 7 out of 10 restaurants are single unit operations. 8 out of 10 restaurant owners started their industry careers in entry-level positions. 9 out of 10 restaurant managers started in entry-level positions. Restaurants employ more minority managers than any other industry. Nationally, since 2019, 90,000 restaurant locations have closed either temporarily or permanently. At the end of 2021, national restaurant industry employment was down 1 million people from pre-pandemic levels. We are asking TASER to study the following issues. Number 1, study Tennessee's liquor by the drink taxes and how they compare to surrounding states. 2, study staffing challenges specifically related to the restaurant industry. 3, study permitting costs and other costs relating to training necessary to operate a local restaurant. And 4, study other possible barriers and challenges to the restaurant business and how the state could help minimize these barriers. Mr. Chairman, I'll try to answer any additional questions the committee may have.
Okay, the one thing that I would at least try to put on record is if this passes, I still think TASER is kind of up to the speaker which ones are chosen.
Okay.
So even if you pass, I don't know what happens beyond at the speaker level.
I understand that.
Any committee members have any questions? Seeing none, those in favor say aye. Aye. Opposed? Bill moves on to full.
Thank you, Mr. Chairman. Thank you, committee.
Oh, that was the amendment. Let's vote on your bill.
Yes.
I got so involved in your explanation there. It was,
I was so excited that it's
so we're now voting on HB 2419 to move on to full. Those in favor say aye. Aye. Opposed? Now you can move on.
Thank you again, Mr. Chairman and committee.
And seeing that Our main white-haired guy has showed up. We're going to pass the gavel over to him. So let you get back on your feet. So we're going out of session. I said the main one.
All right, we are now back in session, and members, let's turn our attention to top of the calendar, item number 1, House Bill 819 by Chairman Holsclaw. We have a motion and a second. Chairman, I see an amendment. Would you give us the drafting code, please?
It is 013851.
That is correct. Right on. So, do I hear a motion and a second on the amendment? Motion. We got it. We got that. And is, I think it, does this amendment make the bill,
Yes,
Chairman?
it does.
So let us go ahead. Let's vote on this one, get it on the bill since it makes it. Let's go ahead and vote. Those in favor, please say aye. Aye. Opposed, like sign. Ayes have it. We now have 13851 on the bill. Chairman Holsclaw, you're recognized.
Thank you, Chairman and Committee. HB 819, basically it's a real simple bill. The purpose of it is to close a loophole in our law that is unclear regarding minimum markup of high-proof alcohol and wine. Basically, wine cannot be sold at a minimum markup of 20%, and then high-proof spirits cannot be sold below the minimum markup of 10%. It just closes that loophole. With that, I'll turn it back to you.
That is a good explanation. Now, my back is to most of the members. Do we have any, I can't see, and I have no eyes in the back of my head. We've got a question. No questions? All right. So we've got a call for the question. I see no objections. All right, let's vote. Those in favor of House Bill 819. Those in favor, please say aye.
Aye.
Opposed, like sign. Ayes have it. House Bill 819 moves on to full committee, of course. Moves us on down to item number 2, House Bill 1689. And we have, okay, gentlemen, thank you. Thank you for that motion and second. However, we do have an untimely amendment, and before we move further, I think if there's no objections, Chairman Holsclaw, would you explain this untimely amendment for us, please?
Thank you, Chairman and Speaker. Basically, the untimely amendment was in reference to a couple of items being requested to be premier resort items, and we're looking to add that to the list of. It would probably been 19 to 20. Now we're going to make it 22.
Okay. So what we have, members, substantive Yes, I guess so. You could say that. But still, it's just an addition to the existing list of 2 more locations. So that's it. Do we have a motion then to approve this untimely amendment? Did I hear? Yes, I did I? Got a motion. Did I hear a second? Okay, got it. Got a motion and a second. Questions to the sponsor? Hear a call for the question? Yes, we do have a call for the question, and I see no objections. Let us vote on House Bill 1689 as amended. No. On the amendment. On the amendment, I'm sorry. Excuse me, members. On the amendment. Those in favor, please say aye. Opposed, like sign? Ayes have it. Now, we are on the bill. At this time, if there are no objections, we are going to go out of session, and we're going to take a brief recess. We're not going to go then. I'll ring us back in session then. All right, we are going to take a brief recess then. All right, members, we are now out of recess. And we're back, and let's draw our attention. Are there any, we've got the motion and a second, any questions to the sponsor, bill sponsor? Any questions? See, we're on the bill as amended. All right, do I hear a call for the question? Got it. Call for the question, and I see no objections. Let us vote. Those in favor of House Bill 1689 as amended, please say aye. Oppose, like sign. Ayes have it. And we are.
Thank you, committee.
Where's that going? That's, of course, going on to full, of course. Full. Okay. We'll go out of session, and I'll hand the gavel back to Chairman Holtzclaw.
You've done such a wonderful job. Okay, we're back to. So it looks like we're on item number 10. Is that correct? HB 2113 by Eldridge. You are recognized, young man.
Thank you, committee. Thank you, Chairman and committee. HB 2113 is just pretty much what it says in the bill summary. It's requiring the Department of Corrections, Department of Mental Health and Substance Abuse Services, and the Department of Human Services to work with a nonprofit charitable organization to provide mandatory annual training in identifying and intervention, prevention, and treatment of human trafficking victims, and the proper action that should be taken when dealing with a known or suspected a victim of human trafficking. This was brought up by the End Slavery and the TBI Advisory Board. And currently, the Department of Corrections does require training in human trafficking, and it was created by a nonprofit organization. And based on other information with the Department of Human Services and the Department of Mental Health and Substance Abuse, there's no change. This can be done during their annual training. So that sums up the bill, and I'll stand for questions.
Okay. Looking at this, it shows no physical notes. So is this like a video training or that kind of stuff?
That this can actually be done during their regular annual training. It's not going to change anything.
Committee members, anybody have questions? Questions been called without objection. HB 2113, we're voting on. Those in favor say aye. Aye. Opposed? You're moving on to full, young man.
Thank you, Chairman and committee.
We're now on item number 12, HB 2222. You should have run this earlier in the month. Representative Powers, you are recognized. Do I have a motion, second?
Yes,
And you do have an amendment. What's your amendment code?
I do. And in poker, that's 4 deuces. That's 2. But my amendment number is 013461.
Got a motion? Second, so you're properly before us.
All right. Thank you, Mr. Chairman. Thank you, committee. House Bill 222222, it just simply authorizes law enforcement to enforce the criminal laws of this state and authorizes them to make arrests for violations of 8 U.S.C. 1324, Section 2. And just mention, I have a copy of that here. 8 U.S. Code 1324 is simply titled Bringing in and Harboring Certain Aliens. The Tennessee Post Commission should develop law enforcement training that explains how officers can already make arrests in compliance with this. When first drafting this bill, we were trying to figure out a way to prevent or to somehow control people that are coming into our state. We've got people that are being flown in the middle of the night in Chattanooga and Knoxville and maybe other places too. So we looked at that and we found out that our law enforcement officers under this code already have the authority. And I'm going to quote Section C, all other officers whose duty it is to enforce criminal laws. So law enforcement already has the authorization to do this. This was just simply bringing training to them during the Post Commission, and it just pertains to anyone who facilitates bringing illegal aliens into our state or harboring them once they are into our state. You know, the governor recently requested from the president information regarding those who have been transported to our state. As far as I know, there has been no response. So we're just trying to make law enforcement aware that they can already do this and have some training set up through the Post Commission. And with that, Mr. Chairman, I renew my motion.
Questions by the committee? You're a quiet group today. Seeing none? Move for question on amendment. Those in favor say aye. Opposed? Ayes have it. We're now on the bill. Any additional comments or questions? Seeing none, we're voting on 2222. Those in favor say aye. Opposed? Ayes have it. You're moving on to full.
All right. Thank you, Mr. Chairman. Thank you, committee.
We're now on item number 13, HB 1994, Representative Griffey.
Good afternoon, Mr. Chairman and members of the committee.
Do I have a motion and a second? Motion. Got a motion and a second? And you are recognized.
Thank you very much, Mr. Chairman, members of the committee. What House Bill 1994 would do would be to instruct the Commissioner of Safety in collaboration with the Commissioner of Human Services to develop and implement a system to identify and relocate illegal aliens that are here in this state as soon as they can within effective time to other states such as Delaware and California, where a number of the current administration officials are their home county's constituency. And simply, that's what it does. And the reason I submit that the state has the authority to do this is that this past February 7th, 2022, the Attorney General of the state of Arizona, Mark Bronovich, indicated that the state self-defense clause of Article 1, Section 10 provides that a state may defend itself when it has actually been invaded or in imminent danger, as will not admit of delay, and the state does not need the consent of Congress to do so. The invasion clause of Article 4, Section 4 provides that the United States shall protect each state in the Union against invasion. These clauses provide dual protection against the invasion broadly defined. This includes defending against actions, foreign hostility, and ambiguous or vindictive enterprise of a state's more powerful neighbors. This encompasses the defense against hostile non-state actors, such as cartels and gangs operating at the border within a state. James Madison specifically cited Virginia using its militia to stop smugglers as an example of a valid exercise of the invasion power. And there's every basis to conclude that the sovereign power was retained by the states in the self-defense clause. So in short, Mr. Chairman, members of the committee, I know the Department of Safety feels like that there's concerns or problems with this bill legally, constitutionally. I submit those can be challenged in court if they want to, but I believe the Constitution, as Attorney General Mark Bronovich from Arizona has indicated, that the state retains the powers to take these actions if there's active invasion going on. And I think we've seen from the actions of our current administration, D.C., that there is an active invasion going on at our southern border, and Tennessee has the obligation and the right to act if it so chooses. And that's moved for passage on that basis.
Committee, your representative. Recognize Representative Beck.
Thank you. And normally I just stay quiet when you're doing this political posturing. But, you know, Representative Griffey, this is such a mean-spirited and ugly bill. You're asking our Department of Safety to hunt people down like dogs. This is America, for God's sakes. Land of the home of the free, and land of the brave. We're not here to, like the Russians are hunting down the people in Ukraine, and then on top of that, you want to put them to Biden's Delaware or out to California. This is just, I know that you're going to be running for office, but it's obscene, and I would be embarrassed if I was you to bring this, such a mean-spirited resolution.
You are recognized.
Thank you, Mr. Chairman. I'd be embarrassed to advocate for a position that allows lawlessness to continue in the United States and take advantage of the citizens of the state of Tennessee, who you're obligated by oath to defend their rights. Thank you very much, Mr. Chairman.
Other questions, comments from the committee? Representative Keisling, you are recognized.
Thank you, Mr. Chairman. Do we have anyone from safety that might want to go out of session and have testimony from them? We
And
do?
at the will of the committee, we're going to go out of session.
Thank you, Mr. Chairman.
And we're going to listen to two individuals, Elizabeth Stroker and Marsha McShane. So state your name and who you're with, and let it go. You got 3 minutes.
Yes, sir. Elizabeth Stroker, Legislative Director for the Department of Safety. As Representative Griffey mentioned, we are philosophically opposed to this bill. It is not the responsibility of the Department of Safety to try to locate people who are in the country unlawfully. We actually are expressly prohibited from doing that through federal jurisdiction and authority. Immigration laws are specifically for federal jurisdiction. We can only do that if we are working in conjunction with the feds to be able to even do that. Additionally, entering the country unlawfully is the criminal act. Remaining present is not. And so there's no situation where we are going to be catching someone coming at the border where we could actually watch a criminal act take place. The immigration process or removing someone from the country is also a civil process. The department does not have any involvement with those civil hearings or civil procedures. Again, it is all done on the federal level. And so we feel like this could be considered kidnapping. Our officers would be subject to liability, both criminally and civilly, for trying to locate these people that we have no information if someone is in the country lawfully or not. That is verified through federal immigration. That is not something that we have access to. And if we detain someone, we could be detaining them unlawfully, transporting them across state lines, which turns into federal kidnapping. And we are absolutely not okay with opening ourselves up to that liability when we do not have that authority or jurisdiction to do so.
You are recognized, Representative Bricken.
Thank you, Mr. Chairman. I would just like to ask the Department of Safety, if in their performing their duties, any safety officers, whether it's upon arrest or identification, identifies undocumented illegal immigrants in the state, is it a matter of policy to notify federal law enforcement or immigration ICE officials of those individuals and let them do their course of work?
Elizabeth?
Yes, sir.
Other questions, comments? Thank you for your testimony. Excuse me. Okay. Looks like we're going to go back in session. And any other questions for Representative Griffey?
Mr. Chairman.
You are recognized.
Thank you, Mr. Chair. I just want to comment to some of the statements by the Department of Safety. Respectfully, I've got a little more faith in the opinion of the Attorney General of the state of Arizona than the Department of Safety on some of these legal issues. This is going to be a constitutional battle. It's going to be a court battle, and that's what I think should happen. I also would submit, respectfully, the Department of Safety's duty is to do what this body tells the Department of Safety to do. We are a sovereign, the state of Tennessee, and we still retain constitutional sovereign powers, separate and apart from the federal government. We're not a subject of the federal government. And as Attorney General Bronovich explained in his opinion, and I'll be happy to provide it to anybody that wants it, if the federal government has failed upon its duty to protect the sovereign states from invasion, the states have the right and the obligation to act if they want to. And with that, I just move for passage. Thank you.
Other questions, comments? Seeing none, we're voting on HB 1994. Those in favor say aye. Those opposed? No. Bill fails.
Thank you, Mr. Chairman. Thank you, committee.
We're now on HB 2379 by Representative Parkinson.
Thank you, Mr. Chair. And
it looks like you do have an amendment. Is that correct?
Yes.
What is your drafting code?
014314.
That would be correct. I have a motion second on the amendment.
Motion and second on the amendment.
About got real cold in
It
here.
did get cold. I come in peace, gentlemen and ladies.
All right, you're properly before us, so explain your amendment.
Thank you, Mr. Chair. And what this bill does is this. We passed online sports gaming, and there's a lot of money being made off of online sports gaming. What this bill does, it codifies in the code that if one of our restaurants or hotels wants to utilize their internet to have people to use their internet instead of their phones, right? And they come up with a marketing strategy that would encourage people to use their internet versus their own personal phones to get to sports gaming, then they wouldn't be sworn by TBI, basically. And so, we wanted to find a way, well, I wanted to find a way, for my folks on Beale Street to be able to, benefit from sports gaming, to be honest with you. Now, in this legislation, it ensures that they are not touching anything related to the actual bet or the individual's information that goes to, let's say, FanDuel or whoever it is that's they go to take the bet. It's kind of similar to when, if you get on an airplane and utilize their internet, they show you all the stuff they want you to see first, and then you go to wherever you want to go on their internet. And this is kind of along the same lines. And so if they want to say, I'll give you an example, from a marketing standpoint, if they want to say, hey, use our internet 10 times, you get a free burger, then, and then you go on to, wherever you want to go in regards to sports gaming. Or if they want to charge $1 to use their internet, and then you go into, wherever you want to go in sports gaming. So that's what this is. I was just trying to find a way for our people in Tennessee that are in hospitality or arenas to be able to allow for the use of their internet to get to sports gaming without it being thought of as they are tied to sports gaming, if that makes any sense. So that's all this bill does.
We got questions, comments? Seeing none, we're voting on HB 2379 on the amendment. Those in favor say aye. Aye. Those opposed? No. Amendment fails. We're on the bill, HB 2379.
Mr. Chair, let me roll that bill forward to the end of the calendar, if you will, if you don't mind.
You gonna roll it to when?
To the last calendar. Is this the last calendar for this committee?
We're gonna let you roll it 1 week.
Thank you, sir. Appreciate it. Thank you.
Rolled 1 week, HB 2379. Okay. We're on item number 15, HB 1496 by Representative Towns. So if the amendment fails, he can put that amendment back on. Representative Towns, good to see you.
As well, sir.
HB 1496 was previously considered and failed. So do I have a motion to reconsider our actions on HB 1496? It cannot come from Becker Chisholm because they previously voted on it in favor. Sorry about that, bud.
I understand.
With no motion to reconsider, we cannot take up HB 1496. Without objection, bill is taken off notice.
Thank you, Mr. Chairman.
We're having fun in here today. We've got items 16 and 17 by Representative Hurt, but we're going to hear HB 1642 first. Do I have a motion and a second?
Motion. Second.
Okay, don't see an amendment, so you're properly before us, so you're ready to roll.
Thank you, Mr. Chair. House Bill 1642 recognizes an Indian tribe residing on federal lands held by the United States government for the purpose of such tribe obtaining a license from the National Indian Gaming Commission to conduct gaming operations on those tribal lands within Tennessee. So, members, what we have in Lauderdale County is the Choctaw Indians have sovereign ground, federally designated ground that they are pursuing a development, and they would like to pursue Class 3 gaming on that federal ground. And in order to do that, they need to be recognized by the state because they have to make an application to the National Indian Gaming Commission, and part of that application is an agreement with the state, and what's called the next step is a compact to be part of that application to the federal government. And again, that property is located in Henning, Tennessee, which is on the south end of Lauderdale County, right on Highway 51. It was designated in 2012 as federal ground. And with that, Mr. Chairman, I'll answer any questions.
When you say designated as federal ground, so the feds own the property?
Yes, sir, as a sovereign state, yes, sir.
You are recognized, Representative Hoffman.
Will that continue to be federal grounds if this happens?
Yes, sir.
And are we talking brick and mortar facilities here?
Yes, sir. That would on their ground. It would be a brick and mortar establishment.
Thank you.
Other questions, comments? Representative Beck, you are recognized.
Thank you. Has this area always been known in the community as being the Choctaw Reserve? A reservation, not reserve, I'm sorry.
We have always had the Choctaw there on that ground, and they have the larger part of their establishment is in Mississippi, down in the area of Philadelphia, down through mid and south Mississippi. But there have always been Choctaw in that area of Lauderdale County, yes, sir. But it was just designated in 2012 as sovereign ground, where they have now their own police, law enforcement, and their own community. But they're all associated with the tribe there in Philadelphia, Mississippi, where their chief resides and their commission resides.
Representative Beck?
But as long as you've resided there, it's always been Choctaw. This isn't something that we've just dreamed up. It's really Choctaw area, right?
Representative Hurt?
Yes, sir, exactly. And actually, kind of what we were told is during the Trail of Tears, they kind of made their way through that area, crossing the Mississippi, heading out to Oklahoma. And that's kind of when they came back through, that's where a lot of them stayed. And as far as agriculture, kept them there. And then, of course, the chief also told us in hiding stayed in that area. So, yes, sir, ever since I can remember, they have been there.
Very good. Thank you.
So how many individuals reside on this property we're talking about here?
On that property in Lauderdale County is a couple of hundred. There in Lauderdale County, their establishment there with their housing, there's a couple of hundred that stay there. Approximately just under 100 acres was deemed sovereign ground.
And they have their own operating system and the whole 9 yards?
Yes, their own law enforcement and all that. Again, they're associated with the tribe and the chief that are centered in Philadelphia, Mississippi, but they have their own establishment there.
So do they report back to Mississippi, or are they independent of Mississippi?
No, they report back to Mississippi. That's where their chief is located, along with they have a representative from their area that represents them in their meetings.
So my question to you, would the profits of this go back to Mississippi?
The profits of this would benefit the Choctaw tribe, which would benefit individuals there and in Lauderdale County.
Okay, you are recognized, Representative Beck. Bricken.
Oh.
Thank you, Mr. Chairman.
Those beads.
I'm generally supportive of Indian tribes getting into the casino business. I just am curious on a couple of levels. If 1642 passes, what is the progression of legislation or state involvement from this piece of legislation to actually operational casino in Tennessee? I mean, in the conversations we've had, I've heard the term compact, and it sounded like that was a mutual agreement between the tribe, local government, and I think state government. And so, but I don't know, I mean, I'm trying to figure out the progression of this authorization, that this initial, if this is just an initial bill to start the ball rolling, and then kind of where will it go from there?
Yes, sir, and thank you for that, because I would like the opportunity to clear that up. And the way I understand it is this legislation would allow them to start discussions with local and state government to enter into a compact, which is different in every state. It's a negotiation between the tribe and the government and our government on the fees they pay. They'd like to come to agreement with impact fees to pay the locals up to the state. Of course, all that is variable on the agreement, and if they can come to an agreement, that is a critical part of their application, which would then be submitted to the Federal Tribal Gaming Commission that would still have to be approved. And if that can be approved through the Federal Tribal Gaming Commission, then that would allow them to start moving forward with establishing what they want to in the county.
Representative Bricken.
Thank you, Mr. Chairman. But, all right, for a clarification, will some subsequent approval by this legislative body be needed before this tribe could get fully up and authorized or not?
Representative Hurt.
The way I understand it, no, sir. This would be the legislation to begin the ball rolling. The only thing that we could see, and it would be dependent on us, is how that would be made up the committee, or however we wanted to structure who was involved in the discussion in the compact. So we could come back and visit that if they, if we move that way. But the way this legislation would get the ball rolling and would allow them to start negotiations in the compact.
Representative Bricken?
Well, I think that's an important component, that the authorization at the state and local, who is going to be those authorizing bodies to make that compact, to review it and be certain it's in the best interest for Tennesseans, the locals there. It certainly seems like that should be embodied in this legislation before we approve it.
Representative Hurt?
And you make a good point. I have no problem looking into that, if we could get this moving forward, or even if we wanted to roll it and visit that, because that's a pretty deep conversation for sure, and a vital part of that compact. I'm at the will of the committee on that, Mr. Chair.
Representative Bricken?
Well, I don't know from the calendar standpoint where we are for that to get clarified before we act on it at this committee level.
Let's go out of session and hear from legal.
Matt Mundy from legal. I mean, I'm no Indian gaming law expert. It's fairly complicated. It's a foreign nation once they're recognized, and you're entering in a compact with the tribe. I would imagine the state would have some involvement in Tennessee. The locals, governments can't do anything that we don't allow them to do. And I have a hard time imagining, and I'm trying not to engage in conjecture, but I have a hard time imagining that they're going to let one county execute a compact without some state input. Whether or not that means this bill needs to be amended now, or whether or not they would look at the compact at a future date and make revisions to it or suggestions, that's just not a process I'm that familiar with. But I suspect the state would have some involvement in the terms of a compact with a tribal nation.
Well, thank you, legal. I just think we need to get clarification that it's going to come back to this somebody in the state at the level, whether it's in the General Assembly, I would hope, to be certain that the components of it are in the best interest for Tennesseans. So, again, from the calendar standpoint, I don't know if we're going to meet next week, and we maybe could clarify that before we actually vote on it.
Well, that's our last calendar next week, so that's as far as we could extend this. So I don't know. That's up to you, Representative Hurt.
Mr. Chair, I would respectfully ask to see if we can get this moving and have these discussions, and get clarification as I mean, I feel like the state will have plenty of input on that, and the locals will, and I would like to, if it be the will of the committee, to move this forward and continue with this being the last calendar. Next week, you said was the last calendar.
Mm-hmm. So you're willing to roll the dice, so to speak? You're recognized.
Let me rephrase that, Mr. Chair. I guess I went brain dead there for a second. I was thinking this week. So next week being the last calendar, I'm good with rolling it until next week and continue these discussions and see if we need to amend it to add something in there, or if we're comfortable with where it is right now. But that's a absolutely relevant question,
Okay.
Mr. Chair.
We need to go back in session for you. Okay, we're going. Okay, Representative Beck.
Thank you. It just struck me during Representative Bricken's questioning, because it's a sovereign nation, will the state be able to tax these gambling proceeds? Are we going to is this going to be an economic boost to the state as far as taxation?
Matt Mundy from legal. I don't know the answer to that precisely, but I imagine the terms of the compact would dictate any kind of fees or taxes or income that might go to the local government or to the state, for instance, from the operation of a casino. I don't know that to be the case for sure, but it wouldn't surprise me if other states that have these kind of compacts do have some kind of, like the sponsor mentioned, impact fees, to offset the development cost of the development.
Before we get too engrossed, is this for legal?
Yes.
Okay, Representative Beck.
So would the terms of the contract or compact need to be on the front end right now? I guess is my question, because we don't want to put a burden on the local county, and we want the taxes out of this.
Thank you, Matt Mundy from legal. I don't think that the state of Tennessee would have a pecuniary interest in the taxes themselves, because they would be diverted to the Indian tribe for their benefit. But they may have some. You may get some peripheral income from the operation of the casino. All that being said, I think the terms of the contract need to be generally agreed to before the application process even begins, before you go in front of the Federal Indian Gaming Commission. I think they want to know that the state or the locals and the Indian tribe have come to an agreement as to how they're going to operate the casino and the division of any fees and taxes and income before they issue a license. And that's probably, from a practical standpoint, to avoid any kind of conflicts on the back end after they start operation.
Representative Beck.
So if I understood you correctly, we're not going to get the sales tax off the hotel. We're not going to get the sales tax off the bad buffet. We're not going to get the sales tax.
I don't know the answer to that. What I do know is that once the state recognizes them and the federal plan, it's already held in trust for the benefit of the tribe. I suspect that they're entitled to whatever income that they generate on that property, because it's not state property, it's federal property held in trust for the tribe. And so to the extent that they wanted to enter into negotiations for the purposes of getting the state's permission to build this casino and recognize them, it might behoove them to give the state a taste of whatever they're bringing in for the purposes of approving that compact.
I think that's a very important point. Thank you very much.
For other explanations, I see individuals shaking his head back there, is Skip Armstead. I'd like to give you 3 minutes to indulge us with your knowledge. Thank you. State your name and who you're with, for the record.
Name's Charles Armistead.
You hit your red button up there.
Name's Charles Armistead.
That's it.
1, 2, 3.
Can you stand up?
1, 2, 3.
There you go.
All right, this works now. All right, I just changed this presentation after what I just heard. First of all, thank you all for allowing me to speak. The Bureau of Indian Affairs in Washington City, D.C. recognizes no tribe in Tennessee, no federally land in Tennessee. I don't know how they think they have it, but I can take you to that website and they'll show you. I had the Department of Interior Bureau, a Native American person who was a Cherokee from Tennessee, point that out to me. There are no tribes. The only 3 tribes related to Tennessee are the Choctaws in Mississippi, not Tennessee, the Creeks in Alabama, not Tennessee, and the Cherokees in North Carolina, not Tennessee. No one else around. Secondly, the taxes. The most we can get, based upon the law, is reimbursement for expenses. This becomes, casinos with Native Americans become an economic black hole where money goes out of the state instead of for local goods and services, it goes into another state where the tribe is held. So there will not be a windfall of money coming to Tennessee. We may get reimbursement, but that has to be on the front end. And yes, and this is very important, while the law says, the proposed bill says, that this will be on federal land, the provision in the 1988, the Indian Gaming Regulatory Act says very specifically that a third option is the Secretary of Interior may approve gambling on land that is not federally recognized as reserve. Thus, it's no guarantee it's going to stay there. Next, this bill does not specify a tribe in particular. It says Native American tribes on federal lands. This then approves over 500 federally recognized tribes throughout the world, throughout the United States, and every one of them can have the option of coming to Tennessee. The Seminoles in Florida purchased the Hard Rock Cafe worldwide, and they're turning them into casinos. And if they can get the Biden administrator's Department of Interior to approve the casino, Hard Rock Cafe here in Nashville become a casino, it doesn't have to be on Native American land. That's a loophole that's in the law, and that has been done in other states.
Okay, Skip, we're going to have to wrap it up because you're getting into 3 minutes here.
Yeah, I'm just getting started.
I know.
Why don't I just stop and say, what questions do y'all have of me?
That's what I was getting ready to say. What questions does the committee have of Skip?
I mean, I
Representative Beck,
have
you are-
researched this intently. Okay.
So what you're saying is the state is not going to get any sales tax off this.
No.
Only reimbursement for expenses like roads, sewers, things like that.
But there are other costs that they will not get expenses for. Wherever there has been casinos, the cost to a local community have been up to 6 times the amount of any income that would come to that community because of new social services, because of fraud, theft, new gambling compulsion, addictions. These are hidden costs. And so there is no income coming to the local community or the state to offset those. Only roads and things that you can see.
Thank you.
Representative Keesling.
Thank you, Chairman. Charles, I really don't have anything direct to you. I'd just like to remind the members of this committee, we have a colleague sitting down here that's trying to generate some jobs for his community, his distressed county. That's been distressed, I might add, for a long time. He's tired of being distressed. So is the community. It's bringing jobs to that community. Yes, there's downside to that. I get it. But, he's just working his heart out for his community. And I might add, when I was approached about this, the first question I asked, well, is the local community behind this, Representative Beck? And you know what I got? I got a resolution. Not only did I get a maybe, well, I'm not sure, but maybe, but they went to the county commission. I might add to each, it wasn't unanimous. I wouldn't expect it to be, but it was in the majority. So I appreciate this, and I appreciate this effort on Representative Hurt's behalf for his community. That's what he's doing here today for them. To legal, Mr. Chairman, if I may, this question, what the colleague or the sponsor has indicated, Mr. Mundy, that he's going to, he would like to roll this to the following week. What happens to 16, item 16, House Bill 1938, if he did that?
Chairman, before we get into all that, I think we're getting on the bill, so we'll go back in session.
Oh, I'm sorry. Excuse me.
We're going to go back in session and go ahead and ask your question again to
I'm sorry. I thought we were still out of session, and forgive me for that. To legal, House Bill 1938, item 16, the one that what did we do? What is the posture of this? We were going to come back to it. Was that the posture of it?
Going out of session to hear from legal.
Matt Mundy from Legal. I think that would be up to the sponsor and the committee. I think they're substantively identical. And I don't know that there's a reason to consider both, but that's at the committee's pleasure.
Questions, other comments for legal? Seeing none, we're back in session.
Thank you, Chairman. I have no further questions.
Yes, sir, you are done. Thank you for your explanation and input. Representative Hurt.
Thank you, Mr. Chairman, and a lot there to digest. Again, I ask that we roll this bill, and as we move forward, I would pursue the same on the next. I don't want to get off the bill, but before we close, we'll have more discussion on this next week, and I'll be around to visit each of you. I have the paperwork here of what he was basically accusing me of in front of us, so I'll be glad to get that to each of you. To build on what my representative said there, we do have a distressed community here that we're just trying to get some economic development. I will say, to answer my colleague's question here on the compact, the impact fees are agreed to, which is money that they will agree to pay the state and the locals in the compact. So that's all part of it. That compact has to be part of the application of which they apply. So all of that, it could be a situation where that nothing can be agreed to and there never becomes a compact, which means nothing ever happens. So when you ask about the taxes that they'll pay, they agree to that on the front end with projections of business and things, and they've done it in other states in order to come to an agreement with the state. And the state has to be comfortable with what they're paying for what they're doing, or there will never be an agreement. That is part of the compact. So to say there will be no taxes, they don't pay per se taxes, so they want, in being a good neighbor, what they want to do or what they have to do is come to an agreement in the compact with the state in order of what they're going to pay, and they're called impact fees because they want to pay their part for what they're bringing. And I know we'll have more discussion on this as we move forward, probably next week. But the other thing I would like to say is in looking at Philadelphia, where they opened the casinos in 1992, the economic development in that area is unprecedented, and their crime in that area has gone down. So I want to kind of make that statement here before we leave today. But with that, Mr. Chair, I appreciate your indulgence and would ask to roll this.
What I would also be interested in, I'm sure you're going to work the committee this week and with details, but maybe even pull some information from Tunica, which is so close to us, to see how that's impacted, the community and that kind of stuff in a favor or negative manner. So with that being said, we're going to roll it 1 week. And now we're back on HB 1938, and do I have a motion and a second? Okay, it's probably before, so we're going to do the same thing on that, Representative Hurd.
Yes, sir, please. I'd ask for
Okay, we're going to roll that 1 week, which puts us back to item number
Thank you, Mr. Chair,
3.
Committee.
And that don't look like item number 3 there, but come on. HB 0349 is rolled to the hill, and oh, yeah, but it's already rolled last calendar. HB 0426 is rolled to the last calendar, the special calendar, and then HB 1682 roll 1 week, and number 8 is off notice, which is HB 2387. And be careful when you ask for it to be rolled to the hill of the calendar, Representative Reagan, Chairman Reagan. because you get pain that way. Okay, HB 1749. Do I have a motion second? You are properly before us.
Thank you, Mr. Chair and committee. And I have a witness to testify who was flying in. That's the reason it was rolled.
Okay.
Very briefly, let me introduce the bill before I ask for testimony. House Bill 1749 prohibits the deferring to state agencies over contested cases under Title IV, Chapter 5, which is the UAPA. Essentially, this bill is designed to counter something called the Chevron Doctrine.
Now, are you speaking to the bill? Now, you do have an untimely filed amendment.
Yes,
is that
sir.
correct?
That's correct.
Is the committee willing to take up that untimely amendment? Sure. Have a sure, a second. And we need a motion and a second. All right, go ahead.
On the untimely amendment, basically, the amendment adds the following new section to the bill. Interpreting a state statute or rule, a court presiding over the appeal of a judgment of a contested case shall not defer to the state agency's interpretation of the statute or rule and shall interpret the statute or rule de novo. In other words, from the beginning. After applying the customary rules of interpretation, the state shall not resolve any remaining ambiguity, or pardon me, shall resolve any remaining ambiguity against the state agency. With that explanation, I ask for the amendment to be added to the bill.
Those in favor say aye. Opposed? Amendment's added to the bill. Continue on.
Thank you, Mr. Chair. By way of brief explanation, the Administrative Procedures Act creates a path of due diligence which is outside the normal court routine. The final step in that UAPA is a court, though. The courts, when they take up a case that comes to them, use something called judicial deference. And that deference basically gives the agency that brought the rules which are being contested the court's leaning, if you will. And this bill is about saying no. The courts should interpret the law as they would any other law. They're a court. The judge makes the decision, not the agency. By way of explanation, Colorado has adopted similar legislation. Mississippi has adopted similar legislation. Georgia has adopted similar legislation. Arkansas has adopted similar legislation. Wisconsin has adopted it. Florida has adopted Mississippi, Arizona, and I could go on. The point is that given the agency two bites at the apple is wrong. When they make a rule, it comes through us, meaning the Government Operations Committee and the General Assembly votes on it. That rule is then in place. And if it's contested, the agency shouldn't be able to step in and say, well, we really meant this with that, and therefore the judge should rule in their favor. With that explanation, sir, I would like to go out of session and let you hear from the person that flew in to testify on this.
So, at the committee's will, we'll go to session and hear from Daniel Duell. Is that correct?
Yes, sir. Daniel Duell.
We're going to go out of session. Daniel, where are you? Okay, state your name and who you're with for the record. Once you have your mic on, if he's turned it off.
It's on. Great.
You do have a 3-minute time limit, okay?
Perfect. To the chair, members of the committee, my name is Daniel Duell. I'm the legal policy director at Pacific Legal Foundation. PLF has been around for almost 50 years now. It originated out of then Governor Ronald Reagan's office to protect individual rights and constitutional rights. When people have their day in court, they expect that the judge will be a neutral party that ensures laws are followed and neither party is given an unfair advantage. Unfortunately, many courts, including those here in Tennessee, have adopted a practice that ensures when its citizens go up against the government always has an advantage. Judicial bias refers to the practice of courts deferring to a government's agency's interpretation of a statute, regulation, or other sub-regulatory document. In doing so, judges abdicate their responsibility to say what the law is and instead place a thumb on the scale of justice in favor of the government and against the people. Judicial bias violates the separation of powers by allowing regulatory agencies to make, enforce, and interpret the law. When a court defers to an agency's interpretation of a law in a way that differs from its fairest reading, the agency is no longer constrained by the policy that the legislature adopted. This effectively allows an agency which has promulgated rules having the force of law to make the law that it then enforces. Furthermore, by deferring to an agency's interpretation, courts have given away their constitutional assigned duty to interpret the law independent and without bias. Not only does judicial deference violate basic constitutional principles, it's also just bad policy, knowing that courts will almost certainly approve an agency's interpretation incentivizes the agency to adopt an expansive interpretation of the law in order to maximize its regulatory authority. And I'll just note that in 2019, this body adopted a joint resolution urging the courts to not defer to agencies' interpretations of statutes or its regulations. And as Representative Reagan mentioned, Tennessee is not alone in doing this. A lot of states have done this. And in fact, in Tennessee code already, around 60 times the legislature has instructed courts to review different issues de novo. So this is not outside the scope of what's already been done in Tennessee. And with that, I'm happy to answer any questions.
Representative Beck?
I'm trying to put my head around this. So, and you heard Chairman Reagan say that the different departments promulgate rules and then bring them in front of his committee for their approval. So how are they changing the definition going in front of a judge? That's what I'm missing here.
Yeah, through the chair, Representative, that's a great question. So what happens is when there's any ambiguity, and when looking at regulatory questions, the definition of ambiguity is different than it would be, say, in a criminal court. What courts have basically said is, agencies, you are the expert on these issues, so as long as your interpretation isn't clearly contradictory to the language of the regulation or the statute, we're going to give deference to your interpretation. So there may be some application that wasn't necessarily intended by the regulation, but then the agency wants to use that regulation to enforce against a private citizen. And when the courts defer, they'll just go with what the agency says. And this is a particular problem when you have a change in philosophy among the agencies, because we've seen this at the federal level particularly, where you have a regulation and different administrations come in and interpret that regulation differently, and the government wins in both cases, even though they're saying it means different things.
Okay, we thank you for your explanation. We'll go back in session. And Representative Reagan, I don't know how you think the wind's blowing, but we're out of time, so you can.
I'll close with one statement and call for a vote.
Okay.
The statement I will close for, ladies and gentlemen, is a quotation of Article 2 from the Tennessee Constitution. Section 1, the powers of government shall be divided into 3 distinct departments, legislative, executive, and judicial. Section 2, no person or persons belonging to one of these departments shall exercise any of the powers properly belonging to either of the others, except in the cases herein permitted. There aren't any permitted. Therefore, the judicial branch has the authority and the responsibility to interpret the laws, not departments. I ask for your support on this bill.
All right, committee. Any additional questions, follow up? Okay. What number is that? We're voting on 1749. Those in favor say aye. Aye. Opposed? No. Ayes have it. You're moving on the floor.
Thank you, Mr. Chair and committee.
And now we got a little bit of cleanup to do, and we'll let this next committee take over. Item 349, HB 349 is next calendar by Johnson. 2133, Calfee's rolled 1 week, and 1994 by Griffey's sent to special calendar. That concludes our business. We are adjourned.